Your Royal Highness, members of the Governing Council, honorable judges, office bearers and faculty of the law school, legal practitioners, students, ladies and gentlemen. Thank you very much for inviting me. It's a real honor and a pleasure to have this opportunity to engage with you this afternoon. And thank you all for taking out time to come here and to hear this talk. I'm looking very forward to it. It's something I planned a little different, and let's see how you like it. You've already had an introduction about me. I've been practicing as a litigation lawyer in India, in Delhi, primarily over 20 years, and principally in the Delhi High Court and the Supreme Court. Also before various tribunals. We have many tribunals, quasi-judicial tribunals in Delhi that deal with company law, electricity law, telecommunications law, banking debt, various specialized areas. Now, you're aware that in Western legal jurisdictions, there's typically lawyers are very, very specialized. You won't be a civil lawyer or a criminal lawyer. You will be a lawyer that specializes in patent law, one particular area of intellectual property law. But in India still, as an arguing counsel, you can be a generalist. Also, litigation in India is relatively inexpensive in terms of access to the courts. If you lose, you are not saddled with huge costs. So the quantum of litigation is huge. And whereas in the West, you may have a barrister in England, for example, attending to one case at a time, in India, the numbers are astronomical. So I typically, in a week, argue 25 to 30 cases. So you can imagine the numbers. I've had a varied practice, and that's the pleasure, that's the fun of being in India. It's mostly civil, but also some criminal. I visited Bhutan about 15 years ago. I've left the second visit far too long, I now realize. I was part of a delegation from India of professionals, and we came to study your gross national happiness. I was, the youngest member of this group and very eager to learn about it. And truly, it was an enriching experience. I interacted with various parliamentarians. You had just transitioned to a constitutional monarchy. So it was a time of change and flux. And when I think back to what I learned then and what I imbibed then, which I recall was a very inspiring experience about my takeaway about how a different way of organizing society, of society governing itself, and the goals worth striving towards. These are not often conversations that people have in other countries. And if I look back now, in the last decade and a half, one finds that the world has moved steadily towards greater conflict and, in particular, destruction of the environment. And somehow, Bhutan has, though evolved in that time, yet maintained its unique identity and values. And so I would say that though Bhutan may not be a prominent voice on the international stage, I feel that others would do well to listen to what Bhutan has to offer. Accumulation of wealth may have led some countries to greater geopolitical power, but it doesn't seem to have led their people towards greater happiness. It's precisely because of this insight that I gained that many years ago that I thought that I would try something different and not talk to you on any academic topic, but more on how one should approach legal practice as a litigation lawyer. I felt perhaps this would be a more receptive audience for this conversation. And this is a befitting venue as well. In fact, finding a confluence between GNH and the law could very well be a unique Bhutanese imprint. Also, now with access to technology that everyone has, it's not difficult to garner knowledge. If you want to learn about an academic topic, you can look it up, you can read about it, you can, to some extent, teach yourself. But what do you do with that knowledge? How do you marshal it in life, in court? Where are the books on that? Where is the teaching on how to what to do with that learning in a court of law, how to conduct yourself in a courtroom, how to conduct yourself with clients, with your fellow colleagues? It's not easy to look that up. And that's what I thought that I would dwell on today and talk to you about, because that is something that, you gain through experience. And everybody's experience may be different. And let me share some of the things that I feel are things I've learned along the way. You, as a student of law, and even as a practitioner, of course, you learn the law. But I think what we need to think about more is the importance of learning how to think about the law and its practice, which is where I feel even in teaching of the law, there is somewhat of a lacuna. It's not a focal point. And once that deficiency is there in terms of your educational foundation, that carries forward as a legal practitioner as well. So to understand that distinction, what do I mean when I say the law? Perhaps most of you here may have a notion of it. Perhaps you don't. There may be others, non-lawyers as well. So in common law jurisdictions such as India, which has its foundation in English common law, the law is comprised essentially of two elements. One, statutory law, that is the law made by legislature, parliament, and judge-made law, which is case law, pronouncements of judgments that judges make, and the way that they interpret the statutory law. And these interpretations reflected in case law are also part of the law. And over time they change, they evolve, but they have precedential and binding value. So they are to be followed. If they are to be disturbed, then there is a mechanism of disturbing them by a larger number of judges than the ones who gave a particular interpretation. And therefore, when you learn the law, you are taught both aspects. In Bhutan, perhaps there are other sources of the law as well, customary law, religious law, royal decrees, and so on. But the distinction that I would want to draw is between law which is codified in text in some way, written down somewhere as a regulation, a rule, a statute, could be a decree, and interpretations of that codified law. Both of these, as I said, are part of the law. Now we come to what it means, and what I mean rather, by learning to think about the law and its practice. As litigation lawyers, we need to learn the art of persuasion. The best legal thinkers are often not the best lawyers. We must remember that as litigation lawyers, we are dealing primarily with people, clients, colleagues at the bar, and of course, judges. And we seek to persuade through argument. So, first and foremost, we must become students of human nature, develop empathy, and also gain mastery over language and expression, because that is the means of our persuasion. These are important attributes that a practitioner also must focus on. Now, unlike corporate law, which is all pre-conflict, litigation is a post-conflict intervention. So when clients approach us, they're usually in a state of distress. Their liberty, property, livelihood, peace of mind, any or all of these could be at stake. There may be a civil dispute they are unable to resolve on their own, or they may be accused of a crime. As lawyers, we're not trained counselors, but in practice, we're called upon to responsibly guide clients in navigating through the legal challenge that confronts them. Often, clients approach the situation with emotion rather than objective distance, because they don't enjoy that distance. We as lawyers do. And it's important for us to be able to convey a sense of empathy towards the client. We must try to offer some reassurance, to find a way forward. Just as you know, patients will return to a doctor who has a good bedside manner, with whom they feel a sense of comfort at a time when they're experiencing physical and mental pain. Similarly, clients will remain with lawyers who offer comfort and positivity. Now, that's not to say that you should offer false comfort or make false promises or give false reassurances. You should never mislead the client in any way. But you have to be mindful about being empathetic. Ultimately, our profession is about helping people. And I'm not saying this only from a moral standpoint, as the right thing to do. Even from the perspective of developing a thriving legal practice, I found that you may lose a case, but you won't lose the client if you have treated her well and done your best professionally. Clients, by and large, understand and accept that the outcome is not in our hands. We are in a privileged position. And if you think about it, it comes with a heavy responsibility. A litigant's access to legal justice is ultimately through a lawyer. A litigant has no understanding of legalese. Legal language is a special language spoken by judges and lawyers. We're like gatekeepers of a courtroom. Without us, the litigant has no idea how to enter that courtroom and access justice. And once inside, even then, the litigant is a mute spectator of his own case. He has no voice. It's up to us to be that voice of the litigant, to put across to the judge the pain, the suffering of our client. And we must appreciate this responsibility that we discharge. We have a duty to our client, and equally, we have a duty to the court as officers of the court. With judges, we must remember never to talk down to a judge. You should not, in general, ever make the person you are seeking to persuade, or anyone for that matter, feel like you're talking down to them. While conveying a sense of conviction in your argument is important, you have to walk a fine line in ensuring you don't make the judge feel that you think you know more than him, or that somehow the judge's queries are misguided, although both of those may be true. By nature, I'm not a combative person. My personality is more of a mediator. And yet, in an adversarial system, my friend, my colleague at the bar is an opponent in the courtroom. You're constantly undermining each other's arguments in court. There's a fair bit of dramatics and aggression involved. And at times, even though it shouldn't happen, things can take a personal turn where you end up attacking the opposing lawyer rather than his argument. Also, at times, you may face an obnoxious judge who's being unduly dismissive, and you know deep down that his conduct is unfair. But you feel powerless, since confronting the judge may breach the expected deference to the court and also jeopardize your client's case. The system as a whole can also be frustrating. You may face many cases, where justice was not done. And all of this can take a toll on your nerves, demoralize you, and also lead to anger that you carry with you constantly. It's important, therefore, to be mindful of these reactions and to address them. You have to develop a thicker skin, and you have to learn to let go of anger. I find empathy is the best antidote to anger. If you feel back of your mind contempt for a judge, it will show. And that's a disaster for your practice. That's not to say that there aren't times when respectfully you have to stand up to a judge and show him the mirror. No doubt, being a judge is a higher calling and requires you to elevate yourself beyond personal prejudice. But judges are human beings, like the rest of us, and have similar tendencies. Judges can also be bullies, and at times the power that judges wield can also make them feel omnipotent. So, at times, while maintaining decorum, you have to stand up to a bully, even if he is a judge. You should, of course, only do that when you're absolutely sure that the situation demands it. In my experience, when you push back, most often you earn the respect of the judge. As a lawyer, you certainly must be deferential to judges, but you need not be servile and obsequious. Being a lawyer requires courage and fortitude. You have to keep a cool head in court, where your opponent is trying to constantly distract you. The judge is questioning you, and you have to think and react on the spot. That requires composure. Again, if you're angry, if you're diffident, then you won't be able to think with clarity and harness the focus that you require. The other quality you need as a good arguing counsel is leadership. You have to take ownership of the case, learn how to drive strategy. You're constantly being called upon to exercise judgment and take decisions. And there are many pitfalls to watch out for. For instance, clients often will not reveal the relevant facts to you that would have an impact on the legal merits of the case. It can be because they don't appreciate the relevance of those facts. Or perhaps they simply prefer to focus on what they feel are the positive aspects, as if they persuade the lawyer, then the lawyer will be able to persuade the judge. So their attempt is to convince you. So they leave out the inconvenient. So you have to, as a lawyer, be astute and tactful enough to ask the right questions of your client and get the relevant answers. There will also be times when clients, as well as other lawyers, without intending to, misguide you on things that they will assert to you with great confidence. But again, you have to remain hyper-vigilant. Simply because somebody tells you something with self-assuredness doesn't mean that what they're saying is correct. You have to check for yourself. You have to verify. And that takes me to a larger point. To be a good lawyer, you ultimately have to learn to think independently and innovatively. Above all else, this is the most important ability to develop. And to do that, you need to learn to question everything. What people tell you, your basic assumptions, everything that you think you know. I remember in college, I was in the US for my first degree, and I studied philosophy. Loved it. And I went through a phase where apparently I had a lot of time on my hands, so I decided to create my own proverbs. These were very, very loosely modeled on Chinese-sounding proverbs. And I remember a particular one that I came up with, which was as follows. Knowledge is born of arrogance, but wisdom is the province of humility. I'll repeat that. Knowledge is born of arrogance, but wisdom is the province of humility. what was in my mind when I thought of this was, and it was while studying philosophy, when I was learning to question even things that we imagine in daily life that we are sure about. I see this table, so it must be there. I can feel it, so it must be tangible. And philosophy teaches you to question even that. And so the thought in my head was that we don't really know anything for sure, including the assumptions that we have carried for so many years. And to believe that you know something, truly know something, is a form of arrogance. Whereas wisdom, which comes from humility, lies in recognizing and accepting that perhaps we don't know something. We don't know as much as we think we do. It's okay to be a little unsure. Doesn't make you diffident. Makes you wiser. And that's the kind of wisdom that often comes with age, with time, with experience, where you see things in shades. When, as a young person, you sometimes see them in black or white, in binaries. That's wisdom. And that's what I think the earlier slide said, it's a wisdom talk. I've seen what happens to lawyers and judges after years of practice, and to people generally. Wisdom doesn't always come with age and time. They become set in their thoughts, in their approach. Over time, they've accumulated a great deal of knowledge and experience. Judges listen to, for instance, all kinds of cases, different areas of the law, and arguments are being made. Lawyers, the best lawyers, are essentially bringing all the law and showing it to the judge. And judges over time become very well informed, and they develop a deep knowledge of various kinds of law, areas of law. And so it does happen that they then think they know things. Happens to senior lawyers as well. And that's when you can actually see, you can feel the mind narrow, become rigid. You don't feel that same openness when you argue, that same willingness to listen to a new thought. And that is a death knell for innovation, for creativity, for change. And it's particularly problematic because the law is constantly evolving. It's not static, it's not stagnant. The very fact that it includes case law as it develops means, for instance, in India, that it's developing weekly, because there are hundreds and thousands and lakhs of cases going through the system in a week. In short, the law it's like a shape-shifting knowledge base. And not only must one, as a good lawyer, be abreast of the changes, but also contribute to them. How does that change happen? How does it come about? It's because a lawyer stands up and tells a judge that, look, I think we need to rethink this judgment. Do you agree? If you do, please send it to a larger bench, a greater number of judges to have another look. For that lawyer has to think of why that judgment is wrong and make a new argument for somebody to consider. Also, being a good arguing counsel can be a very lonely journey. When you're in front of a judge, the courtroom may be packed, but you're all alone up there. There's no one to help you, no one to consult. You can't pause and reflect. You have to be clear, confident, cogent, able to pivot, think on your feet, and convey a sense of conviction in your arguments. Confidence, though, should not be confused with arrogance. You can be confident and still be humble and open. To accept your own fallibility does not make you diffident. It makes you wise and open to learning, open to improvement. Now, these are some of the mental attributes of being a good lawyer. And it's something that, very frankly, nobody talks about. But it's important. Those who have lived through it know that these are things that if you aren't mindful of, they'll catch up with you. And you won't course correct when you should. Some of it is just human nature. You have to keep yourself in check at times. You have to think about it, work at it. And now I want to shift the focus to courtcraft, which is the other aspect I want to talk about. In court, there are many variables. And your endeavor before stepping into that courtroom as a counsel is to make your appearance, your experience of arguing the case as predictable as possible. The first question I ask when I get a case to argue, even before I know the merits of the case, is, which judge is it before? My first question to my juniors in my chamber. Who's it before? Why? Because it's very important to study and absorb the courtroom personality of a judge. You may not know a judge personally. You don't need to. But from the judge's behavior in court, you can observe and absorb how that person is in court and with legal cases. You need to figure out, for instance, does the judge hear arguments patiently or rush you along, and plan your argument accordingly? Is the judge a stickler for procedure and technicality? Is the judge easily prejudiced on facts? Or does he observe a more principled legal approach? Does a judge strictly enforce courtroom decorum? Or can you speak across your opposing counsel and get away with it? Some judges, for instance, don't appreciate a counsel arguing in a loud voice. These are things you have to think about, notice, absorb, plan accordingly. These are just a few examples. To make the courtroom experience as predictable as possible, you have to anticipate as accurately as possible and prepare in advance for the questions that the judge might pose, the arguments that your opposing counsel might make, and what aspects might incline the judge to decide one way or the other. To develop the ability to anticipate effectively, a counsel must learn to think objectively from the perspective of a judge, and if possible, the particular judge. Although in an adversarial system, as counsel, we're called upon to make a partisan argument in favor of our client. But we must retain the objectivity to step back from the case and project how a judge might view different aspects of the case, what might trouble the court. You can't ever persuade somebody by exclusively arguing from your own point of view. Those of us who are married face this daily. You must be able to put yourself in the shoes of the judge and see things from the judge's perspective. It's the only way to anticipate what you need to answer even before the judge asks the question. Another technique to anticipate what the opposing counsel might argue. For that, you should start preparation of your case by first preparing the opposing party's case and prepare it the best that you can. You must assume that your opposing counsel will be the sharpest counsel there is, and you should therefore build up the strongest possible case for the other side. Imagine that you are the lawyer for the other side. Only then, after doing that, should you prepare your own case to meet the case of the other side. Best way to anticipate. Reduces the element of surprise in court, which is the goal. And I generally apply this technique much more stringently to what I believe is a strong case in my favor. When I get a case to argue and I feel, having looked at it, that it's a slam dunk, I say, this is where I need to prepare the other side's case much more carefully, because I know that that opposing counsel has got a weak case to argue, and he knows that, and so he will be working doubly hard to find the possible weaknesses. And he'll come up with something innovative. You will have been complacent about it because you think you have a strong case, and he'll get the better of you in court. So you have to be careful about that. If you give in to this temptation of being complacent, then you will be caught off guard. There's also no point in court skirting the weaknesses in your case. Often, counsel who open arguments make the mistake of not addressing the weaknesses in their case in advance of the opposing counsel having the opportunity to point them out. The thought process is, let me focus on the stronger points. The opposing counsel will then answer and point to the weaknesses. I will then get a right of further response when I will deal with it. This is the wrong way to go about things. It's much more effective if you anticipate that counsel is going to argue this. The weakness is unlikely to remain hidden for long. Alert the court to that weakness at the outset and address the issue. It's the best way to deflate the other side's argument even before he's had a chance to make it. So be forthright with the court about the strengths and weaknesses of your case. There's an additional benefit to this approach over time. The judge tends to trust you less if you don't point out the deficiencies in your case. If you disclose them and deal with them, the judge develops an impression that you're a fair counsel who doesn't try to misdirect the court. And remember, while we are expected to make a partisan argument, we remain officers of the court. And that, if I can diverge for a minute, often as lawyers, there are dilemmas that we face in our practice. At times, you find that there may be something which is expedient for the case or your client in that moment. Let's say, for example, you know that the opposing counsel is one who tends to be underprepared. You know that the judge hearing the case tends not to read the file very carefully. And the judge, in the course of argument, is obviously laboring under some mistake about the facts, some misconception on what has happened, which is easily cleared up from looking at the file. But because the other guy hasn't looked at it, and neither has the judge, it's not been pointed out. Now, to allow the judge to continue to labor under that misconception may be advantageous to your client. And one approach could be, look, it's not my job. Why should I? I have to argue on behalf of my client and do what's best for the client. And if the opposing counsel is not good enough to do it, that's their problem. But that too, I would say, is not the correct approach for a couple of reasons. One is that our first duty lies to the court. That, as an officer of the court, that duty trumps our duty to the client. The partisan approach, even in an adversarial system, has its limits. Secondly, if the judge, again, carries an impression that you knowingly misled him in some way or failed to assist the court, as you should have, you will over time lose credibility with the court. The court will trust you less, and your effectiveness in court will diminish. So don't sacrifice that for a case. I remember when I started out in the profession, my father, who's also a lawyer, cautioned me that what we are left with at the end of the day, beyond the money that we earn as lawyers, is the good name that we have built over years of practice. And that reputation can be lost in a day. So you have to be mindful about these things. To circle back to courtcraft, often it is more important to know what not to say than to know what to say. I remember in law college in England, we were advised that if you have to write an essay type answer to a legal question, and you have 45 minutes of time allocated, spend 15 minutes of that time thinking about it, and 30 minutes actually putting pen to paper. And this came as a surprise to me, because the Indian approach tends to be the minute the bell rings, furiously put pen to paper, write as much as you can, as fast as you can. More is better. And I tried this out, and in time I realized that the advantages of that advice that I received, because even though you're spending 1/3 of that time thinking, when you do put pen to paper, there's better focus, better structure, better flow. It's not just a lengthy rambling. Just as the loudest argument is not necessarily the most convincing argument, sometimes less is more. Court time is valuable. It's not endless. If you squander that time by making irrelevant points, not arriving quickly to the nub of the issue, and tactfully positioning your best arguments, you risk losing momentum and the attention of the judge. Every weak argument you make undermines the credibility of your arguments as a whole. So you must learn to be selective. Don't make every argument that occurs to you, in the hope that however unconvincing, one of them will somehow persuade. One of them will hit home. Refine your thoughts and make your best arguments. So you must have a script in your head before you go into court, some structure for your argument beforehand. But there's another challenge. You get into court, and no matter what script you have, how well you've prepared, how effective you may be at anticipating what's going to happen, you cannot account for everything. And often, because the process of arguing is interactive, it's dynamic, you can never be sure how a judge will react to your arguments. And so there are constant surprises. How do you deal with those? You have to learn to be flexible, be able to pivot and course correct. If you're too attached to your script, you won't be able to do that. Let's say you have 3 strong arguments for your case, and you begin as per your script with what you believe is the strongest one. You find the judge is not receptive. Don't yield immediately. Persevere, persist. Try to persuade, but you have to take a judgment call. You have to decide when it's time to abandon that argument, to let it go. You can't keep pursuing it to the point that the judge is now fed up. So you need to be able to pivot, to course correct, to shift focus to another argument, which though you may have believed is the weaker one, it may be time to try that out. And equally, for instance, you have to remain flexible about the relief that you're seeking. You may have hoped for a particular relief for your client, a particular order that you were asking for, but you should always plan for a lesser relief. Because if you find that while arguing that the greater relief seems unlikely, given the reaction of the judge, there's no point keeping on pushing to the point that you come away with no relief at all. If you're obstinate, stubborn, egotistical, arrogant, you will find it difficult to apply this kind of flexibility. It's only when you develop humility of thought that you're able to yield, able to compromise, take a step back and become flexible, all in aid of achieving some relief, albeit not the desired relief for your client. Otherwise, you risk becoming one-dimensional, a one-trick pony who simply knows how to push hard. There are those lawyers in a sort of all or nothing gamble. It doesn't make you a particularly good counsel. Now, we've looked at the mental state you require. I've tried to connect it to how that plays a significant role in courtcraft. If you don't have that mental state, you won't be able to apply some of these techniques. I want to now shift to legal thinking and articulation. As a good counsel, you should be in a position to argue your case without having to take the judge to a single page of the file, of the case file. Showing papers or placing judgments should only be required to make good your argument, not to make your argument. To be able to do this, you have to learn, firstly, to think and express yourself in propositions of fact and law. What are propositions? They're basically the points or arguments that you wish to make. I'll give you an illustration. For example, Ajay's employment was terminated on 15th December 2024 through a letter sent to him by his employer. Ajay responded to the termination by his letter of 20th December objecting to the termination. These are pure statements of fact. These are not propositions of fact. Now consider the following submission. When Ajay's employment was sought to be terminated, he immediately protested the termination. That is a proposition of fact. It has no dates. It has no 2024, this month, by this letter. All of that is meaningless to make your point. The point that you want to make is, when the employer sought to terminate him, he protested right away. That's the point you want to make. That's the factual point you want to make. That is a proposition of fact. It's argumentative in nature. Now, if an employee expeditiously, immediately disputes a termination, then you can never say that he impliedly or accepted it or is deemed to accept it. That becomes your legal proposition. So your argument would be, Ajay immediately protested his purported termination, and there cannot therefore be an implied acceptance of the termination. This is both your proposition of fact and proposition of law combined into an argument. That's how you need to think, and that's how you need to argue. The factual details are not irrelevant. They are relevant to make good your argument. Again, not to make your argument, to make it good. So ultimately, this is something you should be able to orally tell the judge, your point, your argument. You may not remember which month, which year, which letter, which page is that letter on. When you're making good your argument, then you're showing that page. I've told the judge that he immediately protested. I've made the point. Now let me show you. This is the letter by which he did so. That is making good your argument. That's when you need the detail, which you must be aware of. Similarly, case law on deemed or implied acceptance, that's only needed to support your legal proposition as legal support. It's not to make your argument. What the judge wants to know always, and I remember that my wife had, much to my embarrassment, gone up to a senior judge once and asked him at a dinner, Now, what is it that you are looking for in a lawyer? And he says, look, I want the lawyer to come. We are pressed for time. There are many cases. I want him to come, not give me a lecture, make his point and leave. So what is a judge looking for? He wants to know, what's your basic case? What's your basic argument? And you should always begin by explaining the point that you wish to make and then take the judge through the details of the point. Effective arguments are never ones where you approach it like layers of a cake, starting with the first layer, making your way progressively to the last layer and the cherry on top. It's not like reading a book. Start from the first chapter and make your way to the end. Rather, you should begin with the ending and work backwards to walk the judge through the journey to reach that ending. The reason why this ending first approach is more effective is because otherwise, the judge is always thinking and wondering, where is this argument headed? What's the purpose of this? Where is the counsel taking me? And as a result of that distraction and that question that keeps bothering the judge, there's very little focus on what you're actually pointing out. Whereas if you've already told the judge that, look, this is where I'm headed. This is my final point. This is the point that I want to convince you of. Then whatever you show the judge, going backwards and then building up those layers, the judge will immediately understand, I see the relevance of this thing that the counsel is telling me as connecting with the end point that he's already told me. That connection happens while you're arguing. Or the judge may feel, no, this doesn't connect. But the judge is listening to you now and is able to evaluate what you're saying and think about it because you've already told him what the end point is. A common mistake when placing case law. Lawyers will hand over a case to the judge and say, please read para 13 with me. The judge is wondering why. Why am I reading para 13? So before you hand over anything, you should first, to place case law, tell the judge, this is the legal proposition for which I want to cite this particular case. These are the facts of the case. Again, facts of the case doesn't mean every irrelevant detail. Only those facts, simply put, that are relevant to the legal point that is decided in the case. And then briefly explain to the judge, this is what the court holds. Then place the judgment to make good your argument. And so that the judge can see the reasoning in more detail. Two aspects of litigation practice where I find the greatest deficiency amongst lawyers, even with several years of practice under their belt. The ability to read, absorb, explain orally with clarity and simplicity, and if necessary, to distinguish judgments of the court. The ability to deal effectively with case law, to explain it, to distinguish it, and also written submissions, effective written submissions. Written submissions, for those who may not know, is a note of legal and factual propositions that you place to assist the court when writing the judgment. There may be something that you place at the beginning. It may be something that you place after your arguments, depending on the practice that the court follows. The ability to master these two things, how to read, understand, explain case law and then distinguish it, and to prepare written submissions with clarity, are things which I find lawyers have difficulty with. It reminds me of a quote, and it's misattributed to various people. I don't know what the actual source of it is, but it's something to the following effect. I'm sorry about this long letter. I didn't have the time to write a short one. And that captures truly how difficult it is to write something of 5 pages, a written submission of 5 pages versus 10, 15, 20 pages. It's easy to ramble on. To put a point succinctly, precisely, We would see this, for instance, if you look at judgments from the British colonial era of the Privy Council. Short judgments, even of the Indian Supreme Court, the early judgments. 4 or 5 pages, to the point, crisp, such clarity. And now there are hundreds, 100 pages. The sure sign, length of writing is often a cover for lack of clarity of thought. On interpreting statutes or any kind of codified law, what I do is I first read and reflect over the plain text. I read before it, I read below it, I read around it. I don't rush to any case law on it. I don't want to know anybody else's interpretation of it. I want to sit with it, perhaps in the wonderfully peaceful library at the law school, and reflect over it. Look at the plain text. Even if you think you know very little, come up with a thought. What does this plain text mean? How should it be interpreted? And then look for the purposive interpretation. In the context, that provision is in the context of what other provisions? What is this statute trying to achieve? What is the purpose of this provision? Think about these things, unencumbered by somebody else's view. No commentary, no case law. Then, after formulating a view, then go and look up what others have said. Because otherwise, if you read it for the first time after seeing what somebody else has said, you'll never think innovatively and independently. Originality will never strike you. One last aspect I want to cover: active versus passive engagement. When you read something, and bear with me, it's a little bit, I know it's a bit abstruse, but let me try. When you read something, say a legal brief, or you listen to proceedings in court, you can read and listen passively or actively. Which one it is makes all the difference. Active engagement means that you're thinking and questioning while you read or listen. And you're reading or listening through a certain prism of thought. Passive reading is when you simply read or listen without any angle of thought, no prism, no engagement, just absorption. And you start thinking about it after you finish hearing or reading. You are just trying to take it in. You're not engaging with it. And it actually makes a very tangible difference in your ability to retain or absorb what you have heard or what you have read, between actively engaging with it during the process of reading or thinking about it, reading it passively and thinking about it after you've completed reading it. Take an example. Say you have a laser pointer attached to a gun. Should not be using a gun, but just as an example. You know it, you've seen it in movies, that laser pointer will give you that little red dot. When you aim it at something, that little red dot shows up at the target. Now, if you have a laser pointer attached to a gun, then it's like, that is like having, that is active engagement. Why? Because when you point that gun and you see that laser pointer, you see how far off it is from the target. And then you adjust your hand to move it closer to the target. That's active engagement. That's the kind of thing you should be doing when you read and listen. Simply put, question what you are reading and listening as you read and listen to it, and don't start thinking about it after the fact. You'll find yourself retaining a lot more. For example, for this talk, I know that it is now customary almost, and often it seems like a better tool for engagement to prepare slides, put them up. Everybody does it, PPTs and so on. And I deliberately didn't want to do that, frankly, to illustrate this point. If I had put up slides what typically happens is you see what I have written on the slide, which will be some buzzword, some one-liner, and you'll just keep looking at it. And your takeaway from the talk will be those 3-4 things you read on the slide. And you stop listening to what, the nuance, the detailing. What's the point that's being made? Your mind just stops working. It just keeps looking at that image. And then it changes and you look at the changed image. And that's all you absorb. That's passive. Imagine, take a movie. Movie, very enjoyable, very immersive. You now have with 4DX seats that can move, little water sprays that come, scents. It captures all your senses. Wonderful experience. Thrilling. Passive. Listen to music. Much more active. When you read a book, what happens? You read a description of a scene on a page. Your mind's eye takes you to an image. You imagine the characters. You think about what they look like. You imagine them conversing with one another. You're engaging actively. Your other senses are working. That's active engagement. So just to summarize, and I'll close with that, to become a good arguing counsel, you have to develop certain attributes: empathy, compassion, and humility. Half the learning comes from just being mindful of these aspects, thinking about them, which most people don't. Equally, you need to learn to let go of anger and develop a somewhat thick skin. Litigation practice requires leadership, fortitude, and the courage and ability to question others as well as your own assumptions. Arrogance is something you must guard against, especially as your knowledge base and experience increases. Before entering the courtroom to argue, you must anticipate as much as possible. Think objectively from the judge's perspective. Prepare in advance to meet the best possible case of the other side. In the courtroom, learn to keep a cool head. Don't allow yourself to get easily riled or you'll lose focus. Argue with conviction, with confidence. Be firm when you need to be, but always humble. Have the flexibility to course correct in the midst of arguments and learn how to secure some relief for the client, even if it's not the desired relief. Your duty to the court as its officer must trump other considerations. Anticipate and deal with the weaknesses of your case preemptively, taking the sting out of your opponent's argument before he makes it. Learn to think and articulate your case through factual and legal propositions. Prepare to present your case orally without having to turn to the case file or case law. Place the case file not to make your submissions, but to make good your submissions. Read out case law after explaining the basic facts, what the court held, and why you're citing the judgment. Always inform yourself about the judge's courtroom personality and be mindful of it, and always inform the judge of the point you want to make first and then walk him through the steps to get there, not the other way around. Reveal the end point first and then build the argument. Don't start from the beginning and make your way to an undisclosed end. Knowing what not to say is often as important as knowing what to say. Argue with precision, clarity, and brevity. More is often less. One final thought. The legal profession requires time and space to think and reflect. This is an intellectual endeavor. It's only by repeatedly revisiting your thoughts and giving them time to develop, you won't get it right the first time, that you will achieve depth. That kind of reflection has become truly challenging for all of us in today's environment of distraction. Our senses are overloaded with information. We crave constant external inputs. You therefore have to make a conscious effort to become comfortable with your thoughts and develop the ability to reflect with focus. you have to rediscover or discover for the first time solitude. Most important. It's only then that you will discover originality. So please be mindful. Thank you all for your time today.
Hello. Your Royal Highness, Princess Somdeshan Wanchu, esteemed guests, students, private lawyers, it's a wonderful session to be here, and hearing Mr. Anil, I think it was a wonderful opportunity, especially with skills that, with your 2 decades of experience that you have, I feel like we learned quite a lot. So before I ask any questions, is it okay if I give the questions to the students first? Because I feel like they have so much that they want to ask. So if there's any questions from the students.
I've silenced all of you. We can get going and perhaps...
Yeah, if it's okay.
Yeah.
So on a personal note, I know that you have, you and your father, your grandfather were in the legal fraternity. Can I say that, is it because of the influence that they had on you that you wanted to become a lawyer, or were you really inspired to make a change in that field?
Yeah, so in fact, and I was telling Her Royal Highness this also, growing up, there was always a lot of talk of law and politics at the dinner table. And, you know, as a young man, I found it all very dull and felt very stiff. And so that's the impression that I carried. And in fact, I had developed an aversion. So when I went to college, my thought was anything but law. So then somehow I still wasn't sure what I liked. I tried economics. I found it too heavy on mathematics, so I abandoned it. And then I picked up philosophy. And I loved it. It was instantly I took to it. And so at the end of my college experience, first degree, I knew this much, that I really like philosophy. And then I asked myself, what do I do with that? So one option was academia, and I was not interested in that. I had a yearning to apply things in the real world. I felt, though I did have an academic inclination, and if I had a second career, it would be as a teacher. But I was afraid that I would feel isolated in that bubble a little bit. So I then said, law seems like the logical application of philosophy, because the way in which you think, the logic you apply, the structured, methodical thinking, is very similar to how you test things in law. The only difference is in philosophy, there's no end to the questioning. And in law, you have to ultimately find a practical answer for your client. So that's how I kind of, decided on law. And I will say that it made a lot of difference, because it ended up becoming an active choice rather than a passive one.
Which is quite interesting to know, and I think it's nice to see that you've taken law because of the number of experience you have and the skill sets that you just mentioned. I think it's helpful to us in general of what you've learned so far. So if there's any questions from the students, please state your name in class.
Thank you. Mr. Akhil, I think to be frank here, you took out one of the Indian courtroom.
Yes.
Trying to explain how the appreciating judge behavior, how he checks argument, how he simulates and distributes.
Yes.
So just to get your opinion on this, because you said that the adjudication itself is quite complex, and I think it's the challenging job particularly for the judge, because both the parties argue trying to bring from there the kind of case laws and laws. So I think in one of the book I read that the best jurisprudence I want to liability is the law that gives this to the judge. And the best judge is the one who relies this on himself. So when the judge it seems that when you realize this opportunity, sense are right. Then how do we arrive at the right decision? Could share it on this.
Thank you for the question. I often people colleagues in the profession ask me, would you be interested? Not that anybody has invited me, but colleagues ask, would you be interested in becoming a judge? And I say it's too hard. It's too hard because I find it frankly much easier, and I don't know what came first, whether I was always like this or being a litigation lawyer has made me like this. But I have, I'm not a person who rushes to judgment on anything. I may have an opinion, but it's never an opinion which is very strongly held. And I truly believe that every case that comes to me, I will know only the facts that are in the file or what appears from the case file. I will never know what the reality of the situation is. We cannot know. So I accept very deeply and profoundly that the justice that is being delivered is very much man's justice. It is not divine justice. I have no access to that. And with man's justice, it is an imperfect system. It is based on a thought or a hope that we will put in place this adversarial system where two lawyers will argue against each other, and somewhere in between that, the truth will emerge. To catch that truth is the extremely onerous duty of the judge. So, what I have seen over time, and as I said, I find that would be a far heavier responsibility. It's easier to simply argue one point of view, but the judge can't afford to only hear or listen to one point of view. So what I find from observation, judges, there are two kinds broadly. There are different sort of leanings, but you will find broadly two kinds of judges. One, the kind of judge, and I personally have a preference, which I'll tell you. One is the kind of judge who says, look, where do I think justice lies in all of this, based on what I know? And they will find a way through the law to get to the end point of what they feel is a just outcome. That's one way in which judges approach, almost as a policy, their decision making. Other kinds of judges are more circumspect and careful about knowing what the right outcome ought to be, and they will pay more attention to what outcome the law dictates or what follows from the application strictly of legal principles. So you have a sort of almost an end justifies the means approach of some judges. These are judges who are very easily prejudiced on facts. They focus more on facts, and they make judgments. I think you are a crook, this person is honest, etc. And their verdict marries with that judgment or almost moral judgment they make along the way. Other judges don't do that, and they will say, look, what is this is justice according to law. I don't know about the higher justice, and I am not here to deliver that higher justice. In fact, there is an anecdote in Punjabi, which is one of our regional languages. Though I am Punjabi partly, but I don't know the language, but it's in Hindi, if I were to translate it in English, it would be something to the effect that there is a man, a farmer who is before the court, and with folded hands, he's saying to the judge that please give me justice. Please give me justice. That's all I ask. And the judge ultimately gets irritated and said, who's told you I'm here to deliver justice? I am here to decide in accordance with law. So I think that somewhere judges have to decide what their approach is. And that's ultimately going to govern the outcome. That's the best way. That's the best way. Thank you.
Yes. If you have any questions, La?
Thank you, La. I think we were a little bit hesitant because the moderator kept on saying that students, any questions?
Not to exclude you.
Thank you. Just to introduce myself, my name is Tashtile. I am in private practice, slightly been about 2 decades. I also happen to be a member of the Bar Council. Thank you very much, sir. It's indeed an honor and a privilege listening to you.
Thank you for being here. I believe many of your colleagues some of them are in India.
Indeed, indeed. Yeah, thank you. Thank you so much, sir. So, yeah, just to thank you for sharing your experiences. Well, I really, one thing I would like to take one step further from whatever experiences that you've shared. Today, we've reached a stage where artificial intelligence, AI, digital platforms for research, then we also have digital courts. What do you think would remain of us as human beings in the practice of law?
Yeah.
That's the first question. And second question, again, specifically with regard to, based on you having had a very illustrious career, I think the question would be very specific to media. What would be your advice to lawyers who are dealing in cases which have very heavy media attention? Thank you.
Thank you. Those are those questions make you think. To answer the first one, AI. Obviously, the world is still grappling with the impact of AI. There's a lot of fear surrounding it, a lot of concern over jobs and the relevance of professionals in some ways as well. And then, of course, there are those who are very, you also see the potential advantages, streamlining, the saving of time, and so on. What I see happening, I don't, as of now, see that as a profession somehow advocacy will be effaced or will disappear. Where I do see, of course, remains to be seen how it develops and how it's applied. As of now, the application, at least in India, is very limited. And I have an ex-junior of mine who is currently pursuing a PhD, but at the same time has started a company in India where he is promoting AI for the district courts, many of which in India do not have access to very basic facilities. And they face a problem, judges face a problem in recording evidence, in having it typed up, in issuing daily orders. They often don't have stenographers, and there's no effective way. Our higher courts are now quite savvy and are all digitized and so on and so forth. Proceedings are happening on all iPads and etc., tablets and so on. There's virtual arguments that go on. But district courts, it's different. So AI, for instance, is being used there, and it's been a very successful pilot in many district courts to improve the dispensation of justice. So I think that in various places there's a very positive role that it can play, particularly for us in India, where we are grappling with numbers. The system is not able to deliver. Where I see the danger for lawyers, I'll be honest. Today, an AI tool can virtually replace my junior in my chamber. I don't need to ask for research to be done. I can put in a proposition and these tools will only improve. And all the relevant case law will be collated, collected, proposition-wise, and effectively shared with me. This is where I see the danger for younger people and for, by working in chambers, there's mentorship that happens. there's growth that happens, there's learning. So this is where I see a real danger. But otherwise, I don't think it's going to, in the near future, replace the requirement for humans to argue, articulate, and persuade. I think we're far from that yet, so far. The second question, sorry, what was it? Remind me? Media, where so I give you an example, actually, from an early part of my career, which is a case which is very close to my heart. This was, I was just a few years into the profession, and I was defending, I don't know if you ever heard of him, but a very renowned artist called M.F. Hussain, a very prominent painter, made a few movies also. And he faced a lot of criminal cases in India, and a lot of it was political and so on. Be that as it may, there was one particular painting of his which he auctioned, and it was untitled, but subsequently it was given a title by somebody else called Bharat Mata. And it had a depiction of a female figure, and cases were filed saying that this is offensive, and it is inciting religious hatred, and it offends religious sentiment and so on. And there are some laws we have that provide for crimes along those lines. And so I, was appearing for him, and the matter came up for hearing. And in the run-up to the matter, and thanks to him, I was very diffident because I was only a few years, and I asked him. I said, look, I must, in all fairness, and though I wish it were otherwise, but I must fairly tell you that you may want to engage a senior advocate, because I was just 3-4 years into the profession. And he said, no, Akhil, I fully trust you, please go ahead. Now that kind of faith in me, really, it made my commitment, whatever already there was, 110%. What I realized is that there was a lot of media attention. There were a lot of articles, a lot of negative publicity, etc., etc. And at some point, I feared that this would have an impact on the court. And I actually took it upon myself to gather together his friends in the artist community and request them that please speak up and speak out. And I myself started going to TV debates and so on and addressing the issue, generally, of freedom of speech. Of course, I wouldn't speak about the case in particular, but generally. And what I found that did by the time the case was heard is that it just balanced it a bit, and therefore in the public domain, in the media, there were two viewpoints. Ultimately, the judgment came in my favor. That judge went on to become a Supreme Court judge, and if you ask him today, he will say the judgment closest to my heart is that one. And it was a beautifully written judgment. He did research beyond what I had placed. So my answer is that the courts are not impervious to public outcry, pressure. They read the papers, they see what's happening, they know what's happening. It impacts them. They do try, perhaps, to elevate, that is their calling, to elevate themselves beyond that. But they fall prey to it, they are human beings. So sometimes you have to fight that battle also of perception. It is important. Thank you.
Okay, so I would like to take a last question if there is, due to time.
Any students who are, going through a...
I apologize. I like to pick on students.
It needn't be on this topic also. If you feel that there's something that you are grappling with, or a fear you have about becoming a lawyer, please tell me. I'll be able to... So we have one more question. Please.
Thank you so much for the opportunity. I'm Tanu Nochu, a fourth-year law student from the Jimmy Singh Ocha School of Law. And today, our honorable speaker, so there is no doubt that your academic foundation both encompasses philosophy as well as political science. So it has undoubtedly provided a unique intellectual framework both in your career as well as your lifestyle model. Now, I would really be grateful if you can elaborate on how this interdisciplinary approach and background has influenced and enriched your approach to legal argumentation and courtroom advocacy. So by that, in our school also we have courses like philosophy and all, and it would really be interesting, and then it will be really helpful for us to learn how to integrate those subjects into argumentation as well as advocacy. Thank you.
Thank you. Thank you. That's an important question. You know, often people ask me, how, you know, interns, people who are still in law school, you know, what do I do to become a better lawyer? How do I, you know, what can I do? What should I read? And I say, look, don't worry. In law school, you will get a foundation. Some foundation may not be the best, but you may get you'll get a foundation about what are statutes, etc. When you start practicing, you will learn on the job. Don't worry about that. What I always say to them is, you want to become a better lawyer, learn to be analytical. Learn to question your surroundings. When you watch a movie, don't just come out of the movie and say, oh, I liked it, I didn't like it, or have a conversation with your friend. Did you like it? Yes, it was good. Think about it. Articulate to yourself, what did you like about it? Which aspects? Was it the storyline? Was it the characters? What about the characters did you like? Try to find the words to describe what you liked, what aspect of the character, what characteristic. Learn, you know, so you have to just learn to question. That's what philosophy taught me. I thought this table obviously is there, but philosophy told me, hold on, is it really there? How am I sure? In my college interview, I was asked, is it reasonable to assume that the sun will rise tomorrow? That was my interview question at Cambridge. And I gave some answer. I don't know if it was a good one, but I did get in. So, you know, my point is, every day, look, if there's something you subscribe to, a belief system, even faith, nothing wrong with asking the question, why? It may reinforce your faith. For example, in college, I heard from religious clerics in the course of studying philosophy, and I questioned. I did philosophy of science. It's something I enjoyed deeply. And I questioned myself about faith, about the philosophy of science. And at least in college, and my thoughts have refined a little since then, but I came to the conclusion that science is a leap of faith. That was my conclusion after a careful thought process. So my point is, don't be afraid to question and never blindly follow anything. You must know the reason why you believe in something, why you follow something. You must become a thinking, analytical person. You must question, and you must read. Because whatever language it is, without reading, your vocabulary will never expand. And if you don't learn to say what you mean, you'll never mean what you say. We are in the business of people and language, right? We're in the business of words, the nuances of words, interpretation. Our argumentation is based on that nuance. You must have mastery over expression. So that's what I would say, and that's how philosophy helped me. Thank you.
Thank you, Mr. Subal. I think it was a wonderful session, and for us it was very insightful and engaging, and for that I would really like to take an opportunity again to say how grateful we are to have you here.
Thank you.
And to learn so much from you. So thank you so much.
Thank you so much. Thank you.